This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why you lose if you fail to respond to a motion for summary disposition, and why insurers seem to find that fraudsters are often just plain incompetent, and that's why they don't succeed. In a consolidated first-party and third-party no-fault action, plaintiff appealed from two orders granting summary disposition in favor of defendants, including the fraud of the plaintiff. In a case called Kallco versus Melissa Lynn, Pugh et al., the Court of Appeals of Michigan on October 30, 2024, resolved the dispute. After a motor vehicle accident involving plaintiff and Ms. Pugh, plaintiff alleged that he sustained injuries from the accident. A year after the accident, plaintiff brought a negligence claim against Pugh, alleging that because of Pugh's negligence, plaintiff sustained severe, permanent, and progressive personal injuries and serious impairment of a bodily function, including but not necessarily limited to head, neck, back, shoulders. Plaintiff also brought a claim against Citizens for PIP benefits, including medical expenses, work loss, and replacement services. Pugh moved for summary disposition, arguing that plaintiff could not meet his burden of showing he sustained a threshold injury under the No-Fault Act, and therefore he could not maintain his negligence claim against her. Shortly after Pugh filed her motion, Citizens filed its own motion, arguing the plaintiff made material misrepresentations to Citizens regarding the extent of his injuries, which rendered him ineligible for benefits under the statute. The trial court concluded that plaintiff failed to establish that he sustained a serious impairment of bodily function, and therefore summary disposition in favor of Pugh was appropriate. With regard to Citizens' motion, the trial court found that absolutely no genuine issue of material fact exists as to whether plaintiff knowingly made numerous material false statements in his claim for benefits relative to his alleged injuries and the physical restrictions arising out of the car accident. Plaintiff argued that the trial court erred by finding that there was no genuine issue of material fact regarding whether plaintiff met the serious impairment threshold. However, plaintiff's failure to respond to the motions for summary disposition made it impossible for him to support his argument. No argument is not sufficient in any court. The plaintiff tried to use the defendant's evidence as support against the motions. The attempt failed, of course, because the objectively manifested requirement means the plaintiff must introduce evidence that generally requires medical testimony. Pugh presented objective medical records indicating there was no physical basis for plaintiff's subjective complaints of pain. Plaintiff's deposition testimony only set forth mere subjective complaints. Because plaintiff could not show a factual dispute as to whether he suffered an objectively manifested impairment, he failed to satisfy the threshold serious impairment requirement of the statute. With regard to the claim of fraud, a person who presents or causes to be presented an oral or written statement including computer-generated information as part of or in support of a claim for payment or another benefit, knowing that the statement contains false information concerning a fact or thing material to the claim, commits a fraudulent insurance act. that is subject to the penalties imposed by statute. Simply, if they prove he committed and lied, he could go to jail. But this case remains in civil court. That court concluded that an individual commits a fraudulent insurance act when 1. The person presents or causes to be presented an oral or written statement. 2. The statement is part of or in support of a claim for no-fault benefits. 3. The claim for benefits was submitted to the insurer or the state. Further, the person must have known that the statement contained false information. And 5. This statement concerned a fact or thing material to the claim. As to both motions for summary disposition, plaintiff failed to show that any genuine issue of material facts exist. Accordingly, the trial court did not err by granting summary disposition in favor of the defendants. In my opinion, as I get older, the competence of those who attempt to defraud insurers get less and less competent, perhaps because it's just too easy to succeed. Kallco is an example of this lack of competence. He claimed all kinds of injuries and inability to work or play with his children, and when faced with a competent defense, he ignored the motions, failed to respond, and when he lost, appealed, claiming the motions against him gave enough evidence to raise an issue of fact. This was simply a waste of the court's time, and I'm asked why, with such convincing evidence, no criminal charges were brought. Perhaps they're still in the works. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. Please tell your friends and colleagues about this blog and the videos, and let them subscribe as well. If you subscribe, you will get notice of every blog posting, usually 5 or 6 a week, plus access to the more than 4,900 blog posts. You can subscribe to the videos and to the blog postings. And if you're interested in further detail about insurance, insurance claims, insurance law, insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.